Next, I want to go over with you prohibited employment policies and practices under the U.S. Equal Employment Opportunity Commission. So obviously, we're going to be hiring employees for our dealership, and we're going to have employees for our dealership. So under the laws that are enforced by the Equal Employment Opportunity Commission, it is illegal to discriminate against someone, whether they're an applicant or an employee, because of that person's race, color, religion, sex, which includes gender identity, sexual orientation, and pregnancy, their national origin, their age when they're 40 or older, disability or genetic information. It's also illegal to retaliate against a person because he or she complained about discrimination, or he or she filed a charge of discrimination, or he or she participated in an employment discrimination investigation or lawsuit. The law forbids discrimination in every aspect of employment. The laws that are enforced by the Equal Employment Opportunity Commission prohibit an employer from using what's called neutral employment policies and practices that have a disproportionately negative effect on applicants or employees of a particular race, color, religion, sex, which includes gender identity, sexual orientation, and pregnancy, or national origin, or an individual with a disability, or a class of individuals with disabilities, if those practices at issue are not job-related and necessary to the operation of your dealership. The laws enforced by the EEOC also prohibit an employer from using neutral employment policies that have a disproportionately negative impact on employees that are age 40 or older if the policies at issue are not based on a reasonable factor other than age. Now, let's talk about some things. Job advertisements. It is illegal for an employee to publish a job advertisement that shows a preference for or discourages someone from applying for a job because of his or her race, color, religion, national origin, their age if they're over 40, and their disability or genetic information. For example, a help wanted ad that seeks females or recent college graduates may discourage men and women over 40 from applying and may violate the law. Recruitment. It's also illegal for an employer to recruit new employees in a way that discriminates against them because of their race, color, religion, sex, national origin, age when 40 or older, disability, or their genetic information. So, for example, an employer's reliance on word-of-mouth recruitment by its mostly Hispanic workforce may violate the law if the result is that almost all new hires are Hispanic. When you're going through applications and hiring, it's illegal for an employer to discriminate against a job applicant because of his or her race, color, religion, sex, national origin, over 40 of age, disability, or genetic information. So, for example, on that requirement, an employer may not refuse to give employment applications to people of a certain race. And that's pretty self-explanatory, pretty much common sense. If an employer requires job applicants to take a test, the test must be necessary and related to the job, and the employer may not exclude people because of their race, color, religion, sex, national origin, or individuals with disabilities. In addition, the employer may not use a test that excludes applicants age 40 or older if the test is not based on a reasonable factor other than age. If a job applicant with a disability needs an accommodation, such as maybe a sign language interpreter to apply for the job, the employer is required to provide the accommodation so long as the accommodation does not cause the employer significant difficulty or expense. Let's talk about job referrals. It is illegal for an employer, employment agency, or a union to take into account a person's race, color, religion, sex, national origin, age, disability, or genetic information when making decisions about job referrals as well. Job assignments and promotions. An employer may not give preference to employees of a certain race when making shift assignments and may not segregate employees of a particular national origin from other employees or from customers. If an employer requires employees to take a test before making decisions about assignments or promotions, the test may not exclude people of a particular race, color, religion, sex, or national origin, or individuals with disabilities unless the employer can show that the test is necessary and related to that specific job. In addition, the employer may not use a test that excludes employees age 40 or older if the test is not based on reasonable factors other than age. When it comes to pay and benefits, it is illegal for an employer to discriminate against an employee in the payment of wages or employee benefits on the basis of race, color, religion, sex, national origin, age, disability, or genetic information. Employee benefits include sick and vacation leave, insurance, access to overtime, as well as overtime pay and retirement programs. For example, an employer may not pay Hispanic workers less than African American workers because of their national origin, and men and women in the same workplace must be given equal pay for equal work. In some situations, an employer may be allowed to reduce some employee benefits for older workers, but only if the cost of providing the reduced benefits is the same as the cost of providing benefits to younger workers. When it comes to discipline and discharge of an employee, if two employees commit a similar offense, an employer may not discipline them differently because of their race, color, religion, sex, national origin, age, or disability. When deciding which employees will be laid off, an employer may not choose the oldest workers because of their age. Employers may also not discriminate when deciding which workers to recall after a layoff. Reasonable accommodation of disabilities obviously need to be discussed here. The law requires an employer provide reasonable accommodation to an employee or job applicant with a disability unless doing so would cause significant difficulty or expense for the employer. A reasonable accommodation is any change in the workplace or in the way things are usually done to help a person with a disability apply for a job, perform the duties of a job, or enjoy the benefits and privileges of employment. Reasonable accommodation might include, for example, providing a ramp for a wheelchair user, or providing a reader or interpreter for a blind or deaf employee or applicant. Reasonable accommodations for religion. The law requires an employer to reasonably accommodate an employee's religious beliefs or practices unless doing so would cause difficulty or expense for the employer. This means an employer may have to make reasonable adjustments at work that will allow the employee to practice his or her religion, such as allowing an employee to voluntarily swap shifts with a coworker so he or she can attend religious services. When we talk about training and apprentice programs, it is illegal for training or apprenticeship program to discriminate. For an example, an employer may not deny training opportunities to African American employees because of their race. In some situations, an employer may be allowed to set age limits for participation in an apprentice program. Harassment. Obviously, we've talked about this throughout the course. It's obviously illegal to harass an employee. It's also illegal to harass someone because they have complained about discrimination, filed a charge of discrimination, or participated in an employment discrimination investigation or lawsuit. Harassment can take the form of slurs, graffiti, offensive or derogatory comments, or other verbal or physical conduct. Sexual harassment, including unwelcome sexual advances, requests for sexual favors, and other conduct of sexual nature, is also unlawful. Although the law does not prohibit simple teasing, offhand comments or isolated incidents that are not very serious, harassment is illegal if it is so frequent or severe that it creates a hostile or offensive work environment, or it results in an adverse employment decision, such as the victim being fired or demoted. The harasser can be the victim's supervisor, a supervisor in another area, a coworker, or someone who's not an employee of the employer, such as a client or a customer. Harassment outside the workplace may also be illegal if there's a link with the workplace. For example, if a supervisor harasses an employee while driving the employee to a meeting, that would qualify as harassment. Pre-employment inquiries. As a general rule, the information obtained and requested through the pre-employment process should be limited to those essential for determining if a person is qualified for the job, whereas information regarding sex, race, national origin, age, or religion are irrelevant in such determinations. Employers are explicitly prohibited from making pre-offer inquiries about disability. Although state and federal equal opportunity laws do not clearly forbid employers from making pre-employment inquiries that relate to or screen out members based on race, color, sex, national origin, religion, age, such inquiries may be used as evidence in an employer's intent to discriminate unless the questions can be justified by some business purpose. Therefore, inquiries about organizations, clubs, societies, or lodges of which an applicant may be a member, or any other questions which may indicate the applicant's race, sex, national origin, disability status, age, religion, or color, or ancestry, if answered, should generally be avoided. Similarly, employers should not ask for a photograph of an applicant. You should never ask for a photograph of an applicant. If needed for identification purposes, a photograph may be obtained after an offer of employment is made and accepted.